जब इधर को चेयरना है चल ही नहीं रही है माइक जी चल रही है जब इधर को चेयरना है नजर नहीं आएगा या कोई रिश्ता या कोई रीच अगर फोटोग्राफर या अदर पसर अगर उम्र नहीं है Today we are here to release our report, Alleged Perpetrators, which is a report about the stories of impunity. I'm aware that some of you have to run for another press conferences as well, so we'll try to be as brief as possible. Let me first introduce Karthik Murtla. Karthik is a lawyer by his degree, and Karthik has the tribunal for Rwanda for 5 years. And from last 1 year, he's working with us, and he has helped us. Is Gautam Navlakha. Most of you already know him. He is a member of PUDR and also a convener of
These cases range from extrajudicial executions, rape, torture, enforced disappearances, and other violations. The oldest case in this report is from May 1990 and the most recent from July 2011. The focus of the report is twofold. First, it analyzes the specific role of alleged perpetrators, a majority of which are by name, a few by specific designation. Through these 214 cases, we've identified 500 alleged perpetrators. Second, the analysis of their role in these 214 cases is based on a combination of official state documentation and witness statements, signed and consented witness statements from victims on occasion or their family members. The state documentation varies from police records, FIR, police correspondence, police submissions before courts and quasi-judicial authorities like the SHRC, documentation before the SHRC in the stage of a complaint, to submissions made before the SHRC and a final order, High Court, once again from a petition, judicial inquiries which the High Court orders by a lower court judge, final High Court orders, objections filed.
Little bit closer. Just take the mic, please.
And in a few cases, proceedings before the Supreme Court. To ensure that we could gather as much information as available with the state, we filed RTIs on FIR numbers to get copies of not just the FIRs but also what happened after that. The police are obliged to file a final report before a court of law following the filing of an FIR based on their investigations. So we filed RTIs on these FIR numbers. We received some responses, and on occasion we didn't. We also filed RTIs on High Court petition numbers to get the entire record before the High Court for an individual case. These 500 individual perpetrators include 235 army personnel, 123 paramilitary personnel, 111 personnel of the Jammu and Kashmir Police, 31 government-backed militants, Ikhwans, associates. Among these 500 are 2 major generals, 3 brigadiers of the army, 9 colonels, 3 lieutenant colonels, 78 majors, 25 captains, 37 senior officials of the paramilitary forces, CRPF, BSF, IPTK, etc. A recently retired Director General of the Jammu and Kashmir Police and a serving Inspector General. The rationale of focusing on individual perpetrators, besides of course the obvious that under domestic law as well, crimes are committed by individuals, but also under international criminal law, from the Nuremberg trials, there has been an evolution of the concept of individual criminal responsibility. A crime is perpetrated by an individual, and the individual cannot hide behind the cover of a state. Having said that, the strongest indictment in this report is of the Indian state. The Indian state in its various forms, through its various functionaries, judicial and non-judicial, has put in place structures that have directly resulted in these violations. This includes the role of the police when they choose not to investigate, even before that when they choose not to file an FIR, the role of the judiciary, the lower judiciary, High Court and the Supreme Court, and statutory bodies like the State Human Rights Commission. The inference from this report is that the Indian state has been very sophisticated in engaging with the human rights discourse in Jammu and Kashmir. There is a constant reference to a denial of justice, to an illusion of justice in Jammu and Kashmir. But a direct inference from this report is that the role of the state has been far more sophisticated. What they have successfully managed to achieve is to lower the standard of serious human rights discourse. Families approach following a crime a police station and seek that an FIR be filed and investigation is being carried out. The FIRs are not filed. On occasion, an FIR is filed by, instead of the family, on information received from the army or a paramilitary force, which often speaks of militant violence, cross-firing. But then following a public protest, on occasion an FIR is filed. Investigations are rarely carried out, and therefore families approach the High Court. An inquiry is ordered, evidence is heard by a lower court judge who carries out a judicial inquiry on the basis of a High Court order. On occasion, a specific army officer, police personnel is indicted in that inquiry. The matter goes back to the High Court. Ultimately, the High Court orders an FIR or orders for a reinvestigation. The issue and the inference that comes from this report is that what the Indian state has successfully managed to do is lower the standard. Therefore, human rights activists, lawyers, families are constantly searching for minor victories. For example, recently in the Silent case, a 1998 massacre of 19 people, the High Court ordered for a reinvestigation. Therefore, after 15 years, what you have is an investigation of a massacre, nothing beyond. If you look at the FHRC as well, while on occasion recommendations are made for prosecution, it's often about relief. Therefore, the Indian state will allow you to, on occasion, understand what happened in a crime, understand the role of a specific perpetrator, but it will not allow you to prosecute them. Therefore, the standard is lowered in a sophisticated manner through distraction and through relief. The fundamental problem that's highlighted by this report is that there are no proper investigations and there are no prosecutions whatsoever. Following this, therefore, while we list these 500 alleged perpetrators and we discuss their role, we look at witness evidence where available, we look at witness statements, we analyze them. IPTK and APDP in this report does not conclusively pronounce on the guilt of any of these 500 people. But there is material, sometimes very strong material, which would warrant investigation and prosecution. That is the fundamental assertion of the report. Before concluding with the methodology, I'd just like to point you to a few pages of the report. First is page 17, which has a tabular summary. Here are three separate tables. The rank of these 500 alleged perpetrators. How many from the RR, Rashtriya Rifles, BSF, CRPF, how many, and I read out a part of it earlier, how many major generals, how many, different ranks of the police and the paramilitary. Second, Annexure 10 on page 258 is a document many of you will be familiar with. It's under ASPA for any case. The importance of this document, and it frames this report, the specifics of some cases and the larger point being made, is that, and this document tells you, and the inference that has to be drawn from this document is not of a failed law, not of a draconian law like ASPA, but instead a simple message. The Indian state will not prosecute any of its forces for any human rights violation in Jammu and Kashmir. Continuing on the same theme, annexures 11 to 18 deal with court-martials. RTIs were filed to the Ministry of Home Affairs and the Ministry of Defence for information on court-martials in Jammu and Kashmir for paramilitary forces and the army. We received some information for the Rashtriya Rifles. But what you have through these annexures is a series of denial of information. The Ministry of Home Affairs, for example, states that they are exempt from providing information. Different units, CRPF, the BSF, they will not provide information, even though the RTI Act states that there can be no exemption when it comes to human rights related matters or corruption. Last, the issue of awards, rewards and promotions. We have specific cases in the report as well, where there is a linkage made between the practice of providing incentives to officers and personnel of the police and how this practice results in further violations. Annexure 19, page 276. The Jammu Kashmir Police have stated that there are 2,226 persons who received out-of-turn promotions for anti-militancy operations. We're all aware of how, under the garb of anti-militancy operations, human rights violations have taken place in Jammu and Kashmir, and there are examples in this report as well. But what the police will not do beyond providing this number is give you the names of these officers who received the promotions. They will also not give you the names of the militants who were killed in these anti-militancy operations. You will not have the names because it could cause danger, they say, to the officers and their family. You will not have the names of the militants because it will cause a law and order problem and it will hit the sentiments of the people. Therefore, the Jammu and Kashmir Police will award officers by giving them promotions, but you won't know who they are. I'll end with just 3 points on methodology. First, the report does not privilege state documents as being final documents of truth over that of family testimonies. That's not the inference to be taken from this report. We are not asking you to believe that a crime has taken place because the state says it has in some of these documents. The purpose is to hold up a mirror to the state of its own information, and of course family testimonies as well. Second, these cases are those that came to the IPTK and APDP. It is not a definitive list. As I have already stated, the major problem is investigation, and therefore there will be numerous other cases out there. Just an example, Annexure 24, page 338, is a list of FIRs over the last 3 years. There are numerous other names there, and further investigations have to be carried out and further documentation has to be done. So this is not the final list. Lastly, for a crime that we've analyzed in this report where we have listed, for example, 3 alleged perpetrators, it's clear that further investigation would show that there may have been more people involved. What you often have is situations where a person is abducted, for example, and that is recorded either in an FIR or witness testimony, but there may be more people involved. For example, a commander who ordered that abduction, what happened to this person once he was taken to a certain location, the different people who had knowledge of what was happening. Therefore, the list of perpetrators, even for a specific crime, may be much larger. Thank you.
For the last 12 years, we have been preparing the report, whether it's on election monitoring, whether on the mass day, buried evidence, and the other reports we have been bringing. So this is the continuation of this human rights situation in Jammu and Kashmir. What is the significance of the report? That we are emphasizing that this is not the aberration. The state says they are the aberration, but it is institutional and systematic. The repression here of the human rights violations are here being practiced as a matter of policy and are institutional. Then we are talking about the institution, meaning that the judiciary, the executive, the legislature, the armed forces and the police are part and parcel of it. And the worst form is the legal impunity. Besides legal impunity is the political impunity and the moral impunity. Legal impunity given to the ASFA under ASFA section 7, but the political impunity given by the politician that these are institutionalizing the lies. They are saying these things doesn't happen in Kashmir. Or moral impunity meaning that they are fighting a proxy war. So these things do happen, collateral damage, as they are saying. So we say that this state which is saying that they are rule of law, but on the contrary that they are promoting, they are giving rewards and rewards to the perpetrator. So this is very important, the report, so that we can expose the lies of the state. We are trying to emphasize that we have to bring the perpetrator, because if you see the Nuremberg law, the perpetrator are individually responsible for the crimes they have committed. So we hope that it will continue, and God willing that as we are committed that the process will continue, and this will continue in future also. Thanks.
First, Gautam Navlakha to share
the past. With this report, we assert we not only indict the Indian state, but we also point out how it is not possible to get justice through the existing institutions that exist in India for the victims of a war which was inflicted on the people. This is the single most important message of this report, and I think its significance should be kept in mind when you read the whole text. The reason why I point this out is because hitherto, whenever we have come out with a report, we have left the door open for the Indian state, its judiciary or the state authority, the police or the civil government or the state government, to take note of it and to take steps in the direction of providing justice by bringing the perpetrators of violence, convicting them, to bring closure in the lives of people which they have been waiting for, whether these are people who have suffered enforced disappearances, massacres, who are still chasing killers of their near and dear ones, etc., etc., etc. Indian law, Indian judiciary has proven itself to be incapable to provide justice for the kind of crimes that have been committed. Jammu and Kashmir is not the only place where this has happened. Northeast is another area where the similar conditions exist. Not a single perpetrator has been brought to justice. At best, the high courts or the lower courts or the superior apex courts have given compensation, blood money, to the victims of those crimes. The significance of this report lies in drawing attention to this very important fact, that the Indian domestic law, criminal law, does not entertain the notion of crime of enforced disappearance, crime of genocide, crime of torture. Therefore, a range of crimes that have taken place in Jammu and Kashmir are beyond the realm of India's criminal justice system. It is therefore we turn to the international community to remind of their responsibility, to put pressure, to make India feel as an Indian and a self-respecting Indian. I feel dishonored by the kind of crimes that have been committed in Jammu and Kashmir. This is just a tip of the iceberg, yet it's a window into what took place in the last 22 years. And it's that reign of impunity which persists. For us, in short, our search for truth and justice and our conviction in the rights of people to decide their own destiny is taken a step forward, I believe, with this report. Thank you.
I'd like to inform you that we have submitted this report to the Chief Minister's office, and as well as to the Prime Minister of India's office, and also to the Home Minister of Jammu and Kashmir. We are hoping that they would read this report and use it for measures at their end. We would now like to, and we would direct the questions to the relevant person.
Turmoil naturally, in one word. Sense of outrage is going to find its own way of manifesting itself. What shape it takes, let's see.
Any more questions?
State that Jammu and Kashmir is not capable of providing justice to the crimes that have been committed. And in that sense, you are, these are some of these cases that may be there. I mean, these are crimes committed from 1990 till last year, also reported in the international media. How would you hope to reach out to the international community now that you're leaving the Indian judicial system and work with the Indian judicial system for justice in this case?
In the report itself, we've hinted and we've flagged certain issues. Gautam spoke about it as well, about the issue of how certain crimes are not legislated upon within the country. He mentioned genocide, crimes against humanity, torture, enforced disappearance. And I think one of the ways to go further is also to engage and look at and discuss the role of international institutions whose powers range from judicial powers to also investigative and fact-finding powers, and look at how they can now engage with these issues and engage with this material. The material is now public, and it's a question of how we as a group, and of course beyond us as a group, I think this report also is important for the community as a whole, and how all of us can then raise those specific questions to those specific organizations and take it forward.
The kind of perversions and corruptions that have come in to the body politic and body structure of Indian state, and will work towards rectifying it. I just hope that there are people like that in the Indian establishment who would take note of these, the fault lines, and work on it. Beyond that, I have asked it to bring it out into the public, engage in public with this issue, create an informed public opinion both internationally as well as in India, because I personally believe, and I think we collectively also believe, that finally people have to intervene in this matter collectively, because the state is not going to accept what you say. Just because you are asking for it, one has to fight for it. And this is our way of putting up that fight, our way of engaging.
It is in the report, but these are...
I mean, don't you find significant? I mean, you have 2 major generals, you have 3 brigadiers, you have 9 colonels, 3 lieutenant colonels, 78 majors. Now, as far as the names are concerned, the names are there in the list. We would all expect you to come to the list after you have read through this report. Really, we would request you to spend some time. I mean, 2 years have gone into making of this report. Hundreds of people who have been collectively working and have contributed in their own way. Read through this report and then come to the names. And I think then it will draw, the significance of the names would become then clearer.
Can I ask another question?
Yes, please.
I also find it in the report that, about impunity, or impunity is available to the perpetrators of crimes, right from the commission of the crime to the final cover-up, which happens between the investigation and the judicial action on that.
Prosecution.
So in that kind of a scenario, what is the victim's recourse to any justice? I mean, does he make appeals? There seems to be, it indicates an end of the potential for finding justice in the available system. But what does the victim do beyond that? I mean, apart from appealing, if the victim doesn't really have anything, when I read that portion of it.
About this report, it's 300 odd pages, based on RTIs filed across. There's a great power in documentation as well. This report comes from, of course, family testimonies and those appeals which have gone for so many years. And you have so many families who have gone to the High Court And there are examples in this report where they've gone not once but twice and thrice. The numerous contempt petitions filed. Just today there was a news item which actually is linked to a case in this report, where the police have now also confirmed that there are these two people involved. That documentation has its own power, and we've seen that through this report. It is not enough, certainly. This report obviously will not fundamentally change the demands of victims or the community at large. But the documentation has its value, and that's the challenges I think are now upon us to go beyond this report as well. Read the report, look at it, have discussion on it, but like your last question was, what do you do next? And I think that's what we have to do next. Now take this same documentation, which is based on the work of so many different people, including journalists who reported these cases, and now take it further and further. Not with hope from the Indian system, because this clearly establishes their culpability, but with the strength of the documentation beyond the Indian system.
But specifically, what is a victim? Suppose I am a victim, what do I do? I understand what you're trying to do, and I understand the value of it. But as a victim, what am I supposed to do? I've been to the High Court, and I know victims who've been to the Supreme Court, and I know victims who tried to find ways to reach the International Court of Justice, and it's not been possible. So I'm supposing that I am a victim. So what do I do beyond this? I understand.
Can I say something here? I think two things you must understand. When you bring out a report like this, what you're doing is trying to create a public awareness, bring the authorities to shame. Make the international community aware of it. Take it wherever we can, through various international bodies as well as domestic bodies, because in India the Civil Rights and Democratic Rights Organization also provides a platform for us, just as internationally we have recourse to a number of multilateral agencies, etc. The other is, as far as the victims are concerned, in this atmosphere where the authorities are brought to shame and a public pressure builds on them, we believe that the victims stand to gain from that climate which is in defiance of that impunity, which is trying to expose and challenge and bring accountability into the body politic. It will start and trigger off that kind of a process. So what we are doing is not interrupting anything or aborting a process. What we are doing is actually by making and shaming the authorities. And as an Indian, as I said, I mean it very seriously. I feel dishonored. Therefore, I believe victims stand to gain. Whatever they are doing and engaged in, they are not supposed to give up. We believe that this report and the debate that it generates, and we hope and we turn to you to help us in that, spreading this, will create the climate which will bring pressure then on these institutions also to start behaving themselves.
Other than that, what do you intend to achieve by bringing this report before the international community, given the fact that India is a rising power? It's now allies with US and Europe, so I don't see a point where countries like Britain...
On the contrary, my dear sir, that's precisely the reason. India is a claimant to United Nations Security Council permanent membership. Please remember that. In a climate where a public debate is going to ensue over India's candidature, it is absolutely important and imperative that we bring on record the role of India in living up to international law and conventions, whether they have acted in consonance with them or in violation of them, and therefore whether India is worthy of occupying that role. So my dear sir, bringing shame and bringing pressure is by generating debate. That is our role. That is our role. We are part of that process of being in the public domain, bringing issues to the public domain where this can be discussed publicly and not by authorities and small committees and other interested people dispersed in some remote corners here and there. That's all. It's as simple.
Any more questions?